Hi, everyone. This is Todd Pearl from Pearl Properties, powered by Keller Williams Beach Cities. Today, we are bringing you Estate Planning 101 and why you need to know about this really important area of the law. Today, our guest is attorney Robert Theofanis of Theofanis Limited, a well-established estate planning firm in the South Bay cities of Los Angeles. Hey, Robert, how are you today?
Hi, Todd. I'm doing well. Thanks for having me.
Oh, absolutely. Thanks for making yourself available for this very important topic. So, Robert, why don't you share a little bit about yourself and your firm before we dive into the questions?
Okay, great. So, as you mentioned, I am an estate planning attorney, also known as trusts and estates. That means that I help my clients put in place estate plans that will cover them if they become incapacitated or pass away. And I also help clients settle the estates of their loved ones, whether we're doing a probate administration or a trust administration following the death of a loved one.
Okay. And what is an estate plan?
So, an estate plan is a set of legal documents that ensures that a client's wishes will govern in the case of that client's death or incapacity. The typical documents that comprise an estate plan are revocable trust, which is also known as a living trust, a pour-over will, durable power of attorney, advanced healthcare directive, and some other ancillary documents.
Okay, I've heard of the pour over will before. If you have a trust, why do you need a will as well?
That's a great question. So, the trust is the primary document. It's intended to distribute a person's property in accordance with their wishes. The pour over will is best thought of as a safety net. In a perfect world, all of the property will either be in the trust or connected to the trust via beneficiary designation. But mistakes happen, things get left out. And what the pour over will does is ensure that anything that's accidentally left out of the trust eventually makes its way to the trust. Property subject to the pour-over will require probate. We're looking to avoid probate, so that's unfortunate. But at the end of the day, the property will go to the trust and will be distributed in accordance with the terms of the trust.
Okay. So why is estate planning so important?
Estate planning is important because not everyone's wishes line up with California's default rules. California's default rules ensure that your family, your loved ones will end up in court whether you become incapacitated or pass away. If you become incapacitated, you'll go to conservatorship. And if you pass away without an estate plan, you'll end up in probate. Both of those are unfortunate situations due to unnecessary costs, attorney's fees, and other expenses, and very long delays given the nature of the court system in California.
I know that some people are hesitant to plan because they're planning for death and they don't want to think about death. What would your advice be in that regard?
That's a great question because a lot of people put off their estate planning, and fear of death is a major factor in the decision to put off an estate plan. But the truth of the matter is, we're all going to die. There's no avoiding death. What everyone has to decide is whether they're going to confront death and put in place an estate plan for the benefit of their loved ones, or whether they're going to simply avoid the issue, put their head in the sand, and leave a mess for their loved ones. At a minimum, your loved ones will end up in court in the ways that I just described. And so an estate plan is really at its root a gift to your loved ones to help streamline the administration of your estate. So if you're looking for words of encouragement or some motivation, that's really what needs to be the factor that's going to push you through your fear of death, through your uncomfortability with your own mortality, and get you in a place where you have an estate plan set up.
Okay, so who should think about estate planning?
That's a great question. And I think the last question leads into it wonderfully. My informal motto for my estate planning practice is estate planning for procrastinators. Everyone needs a trigger to stop that procrastination that so many of us do. There's two that are very common. The first is real estate ownership, for reasons that we can discuss in a little bit. Real estate ownership is quite expensive when you get to probate. So that's trigger number one. And trigger number two is minor children. Parents of minor children have a lot of factors to consider in making sure that those children are protected if both parents either become incapacitated or pass away prior to the youngest child hitting an age of majority.
If a couple has kids and they haven't done estate planning and God forbid they both pass away, what happens with the kids?
So in that unfortunate circumstance, the family will end up in court. The children will be in what's called a guardianship proceeding. And the purpose of that court proceeding is to name a guardian for the children. Typically, it's brought by a family member or a friend who's asking the court to be appointed guardian. If there's no dispute, then that's good, but we're still in court. If there is a dispute, unfortunately, now the family is going to be essentially suing each other over custody of the children. As far as the property, that will end up in probate, another court proceeding, at the end of which the property will be distributed to whoever is named financial guardian for the children to safe keep the family's assets until the children reach an age of majority, which is 18 in California.
Okay. So when I think about probate versus trust, so wills or no estate planning versus having a trust, I think probate, expensive, public, and I think trusts, private and less expensive. Is that a good characterization?
That is absolutely a good characterization, and you hit the nail right on the head. So in California, there are three reasons, and you hit them, why people dislike probate. It's public, it's a public court proceeding. Anybody can request any of the documents that are filed with the court. It is expensive. The typical cost of probate all in is about 5%. So for example, a $1 million estate, which unfortunately here in Southern California would only include perhaps a piece of real property. All in, you're looking at about $50,000, which includes the attorney's fees and the executor fees and all the other court costs. And finally, probate takes a very long time. Best case, you're looking at 12 to 18 months. Worst case, perhaps up to 3 years. So those three factors, cost, delay, and public, are the reasons that most clients prefer to avoid probate. On the flip side, trust administrations are private. The only document that will ever get publicly filed is a real estate deed, which of course must be recorded with the county. Other than that, everything else takes place privately between the trustee and the beneficiaries. There's no documents for anybody to request, and the administration costs substantially less. To give you a ballpark figure, if we're talking $50,000 for probate, we're probably on the range of $5,000 or $6,000 or $7,000 in legal fees for the trust proceeding.
In terms of the trust administration, so much shorter than the 12 months to 3 years, what would you say is kind of an average for the time period for the trust administration?
So it depends on exactly what needs to be done, but assuming that we have a more or less vanilla estate, let's say a piece of real property, some brokerage accounts, bank accounts, retirements accounts, things like that, you could probably be done with the bulk of the administration and get the property distributed out within a few months. And it'll have to be left open for a filing of a tax return at the end, but the property will be available to the beneficiaries substantially faster than if there's a probate proceeding.
Okay. And is estate planning a difficult process?
No, it's really not. The most difficult part of estate planning is getting started. So again, estate planning for procrastinators, in my experience, people put this off for years and years or decades and decades. Attorney, you're going to have probably 2 to 3 meetings, depending on the attorney, where you design the estate plan, review the documents, and get them executed properly and notarized. Your time investment is probably going to be, 3 to 4 hours, depending on your exact situation, and it'll probably take a few weeks, perhaps a month, depending on scheduling and how fast the attorney is able to get their documents out.
Okay. I think you mentioned this before. So it's much less expensive than going the probate route, but what's the average expense for a full estate plan with a living trust?
Great question. And unfortunately, the answer is a bit lawyerly. It depends. So you can go online. So you can go online and get estate planning documents, the ones I mentioned earlier, which again, living trust, pour over will, durable power of attorney, advanced healthcare directive. You can get those online for $500 or $600 or $700. You could also go to one of the higher end estate planning law firms here in the Los Angeles area that serve high net worth individuals, and you'll get documents. They'll look different, but they'll do the same exact thing. And those could cost between $8,000 or $9,000 or $10,000 and accomplish the exact same objectives. If everything's done properly, and that's a huge caveat with the online documents, because it's not a sure thing that everything's going to be done properly. But if everything is done properly, the estate plan will be successful. The assets will be kept out of probate, the administration will be private, and the client's wishes will govern the situation. So unfortunately, it's a big range, 600 on the low end, 10,000 on the high end. My fees fall more or less in the middle of that range. I've set up my practice so that I can devote as much time as possible to clients, so they're not worried about whether things are going to work, so that they don't have to deal with non-legal professionals or legal assistants and getting their questions answered. But that's a general overview of how much estate planning costs here in Southern California.
So what I'm hearing in your answer is that your clients are going to have a lot of one-on-one communication with you while you're developing this plan. Is that accurate?
Absolutely. And so that's how I've designed my practice. What I've found is that clients are really looking for peace of mind. The legal documents themselves are not the product. They are simply a means to an end. And the end is getting your affairs in order, having the peace of mind of knowing that if something were to happen, that everything will be taken care of. And so communicating with the attorney is a major part of that, to get comfortable, to gain an understanding of what's going on, and to feel like you truly have a grasp of the situation that we're putting in place. And so I focus a lot of my time and effort on providing that level of service to my clients.
That's awesome. And I saw on your website, I like your website, especially the frequently asked
Thank you.
questions part. Yeah. So what I gathered from that is this is not just a cut and dry, we have a relationship for a couple months and we're done. They have absolute access to you free going forward if they have any questions about their plan.
That's correct. So in my comprehensive estate planning packages, I include communication for life. And so what that means is 3-4 years down the road, if you've got a question about an asset that you're moving into or taking out of the trust, I want you to reach out and get that question answered. I'm not going to bill you a 0.1 or a 0.2. I've found that the clients, one, don't like that. And two, if that's the case, they just don't ask and they start making legally significant decisions on their own without the aid of counsel. And so I've set up my fee structure so that all of my clients have access to me to get those kinds of questions answered. And they use it and it's great. I want them to use it. I encourage my clients to reach back out and make sure that whenever they're doing anything with respect to their trust, that they are fully comfortable and don't have any lingering concerns about whether the decision they're making is the correct one.
I think that's great because I mean, I know I can think of more than 5 people just right off the bat right now who don't want to be charged by their attorney. So they don't reach out to their attorney about questions that they have because they don't want to pay a fee. But what you're saying is that in your practice, they do the comprehensive package and they have you for life. That's great. All right. Well, perfect. If more than one person is a trustee of the trust, so more than one person is trying to make their decisions as to how things will go in one trust, but one of them dies, what happens then?
That's a great question. So I'd say a majority or a very solid majority of the estate plans I set up are for married couples or for domestic partners. And so what that means is that during both of my clients' lifetimes in a situation like that, they'll each be the co-trustees. So in the same way that a husband and wife would be jointly responsible for managing the property within the community estate, the co-trustees are jointly responsible for managing the property that's held within a trust where there's 2 people creating the trust. On the death of the first spouse, what most of my trusts say is that the surviving spouse is the sole acting trustee. So again, going back to the non-trust example, if a husband and wife own property and one of them dies, then the survivor is simply the sole owner of that community property. It's the same with my trust. The surviving spouse retains full control of the assets, and they will just continue on discharging the duties of trustee. With that said, there are options, and this is a bit of estate planning 200 level topic, but there are options to create subtrusts where the surviving spouse may or may not be in control of that particular subtrust.
Okay, so people have options.
Absolutely. So the revocable trust is a very flexible document. We can build in all sorts of options and customizations to suit just about every preference there is out there.
Okay. So going back to the co-trustee situation, and when one of them dies, is there a tax consequence?
Well, hopefully not. So if everything has been set up correctly, and we're talking about a married couple here, if everything has been set up correctly, any property that's held within the trust, and so that includes real property and property like stocks and bonds that can appreciate, all of the property will get what's called a step up in basis. And so this is an income tax issue. And what that means is that the tax basis of all the property will step up to the fair market value as of the date of death of the deceased spouse. So, for example, if the family home was going to be sold immediately after the death of the deceased spouse, then there would be no income tax realized by the surviving spouse, irrespective of when that house was bought.
Oh, so that could be huge for people that have owned the property for like 30 years and they bought it for under 100,000, but now, like in our area, they bought it for under 100,000, but now it's worth 1 or 2 million. That could be a huge benefit if they get that stepped up basis.
That's correct. So in Southern California, you hit the nail on the head. There are tons of homeowners who got into their properties, in the low hundreds of thousands, and now their properties are up over 1 million or perhaps even more. Those families are sitting on huge taxable gains, unrealized taxable gains. And if the property is sold following the death of one of the spouses, those gains will vanish and there will be no income tax liability for the surviving spouse.
Wow. Okay. So this is really great information, Robert. I'm glad that you made yourself available for this for the audience. I know we've just touched on the subject, so maybe we'll delve deeper in another interview. But in the meantime, if anyone in the audience has further questions or wants to get in touch with you, what's the best ways for them to do so?
I would direct everybody to my website, theoestateplanning.com. That's Theo, Theo, estateplanning.com. My contact information is there, phone number, email address, and I have booking links where you can book directly into my calendar and schedule a call. Or if you're ready to move forward, just schedule your planning consultation. I've got a ton of information regarding my packages and my pricing. I stand by my pricing, and I'm proud to publish it on the website so that people can review it without having to get me on the phone. And that's where I'd go, theoestateplanning.com.
Okay, awesome. So thank you again, Robert, for making yourself available. And to the audience, thank you so much for tuning in today. If you think anyone else could benefit from this information, please go ahead and share it. And we're going to be bringing you more content like this. So if you want to be alerted to this content, please go ahead and subscribe. But for now, we'll say bye. And again, thanks for being here.
Great. Thank you, Todd. I appreciate the opportunity.
All right. Take care.
Take care.